Today, at least 4 members of the United States Supreme Court agreed to hear Donald Trump's appeal, arguing that presidential immunity protects him from criminal prosecution for the charges filed by Jack Smith against Donald Trump for crimes leading up to and on January 6th. It takes only 4 members of the court to agree to hear a case, and of course it takes a majority of 5 members of the court to issue an opinion in the case. The Supreme Court threw out half of Donald Trump's appeal today and granted a hearing on the other half of the appeal. The part of the appeal that the Supreme Court threw out today was Donald Trump's claim of double jeopardy on the basis that he is now being prosecuted for some of the same crimes he was charged with in his second impeachment trial in the United States Senate, in which a majority of senators voted to find him guilty, but not the 2/3 necessary to convict him. The Supreme Court gave Trump's lawyers 3 weeks to submit their brief and gave Jack Smith then 3 weeks to reply to the Trump brief. Then the Trump lawyers will get a final week for a final written reply. And a week after that, the Supreme Court will hear the arguments in the case on April 22nd. The Supreme Court is not being asked to provide total and absolute immunity for any and all possible criminal conduct by a president. The Trump petition to the Supreme Court only asks for immunity for a president's official acts or, quote, those performed within the outer perimeter of his official responsibility. The argument Trump's lawyers make before the Supreme Court could be a rerun of some of what we heard in the appeals court.
Could a president order SEAL Team 6 to assassinate a political rival? That's an official act in order to SEAL Team 6?
He would have to be and would speedily be impeached and convicted before the criminal prosecution.
What if he weren't? There would be no criminal prosecution, no criminal liability for that?
Chief Justice's opinion in Marbury against Madison and our constitutional tradition and the plain language of the impeachment judgment clause all clearly presuppose that what the founders were concerned about was not.
I asked you a yes or no question. Could a president who ordered SEAL Team 6 to assassinate a political rival who was not impeached, would he be subject to criminal prosecution?
If he were impeached and convicted first. And
so your answer is no.
My answer is qualified yes.
Jack Smith won a procedural point with the Supreme Court today. Donald Trump's lawyers were not actually asking for the Supreme Court to hear the case now. The Trump lawyers were asking for the Supreme Court to send the case back to the Circuit Court of Appeals for another hearing there before the full 11 judges of the Circuit Court of Appeals. In Jack Smith's brief to the Supreme Court, Jack Smith argued that there was no need for the Supreme Court to hear the case at all. But if the Supreme Court was inclined to hear the case, Jack Smith asked the Supreme Court to not send the case back for another round at the appeals court, but to set an expedited hearing at the Supreme Court, schedule that expedited hearing, and that is what the Supreme Court has now done. Leading off our discussion tonight is Neil Katyal, former acting U.S. Solicitor General and host of the podcast Courtside with Neil Katyal. He is an MSNBC legal analyst. And Neil, I want to begin the way all lawyers begin when they get these notices from the Supreme Court that they're going to hear your case. The Supreme Court identified for the lawyers on both sides the question and the only question they want to hear addressed. And I'm going to give that question to the audience now. The question is whether, and if so, to what extent, does a former president enjoy presidential immunity from criminal prosecution for conduct alleged to involve official acts during his tenure in office? How would you address that question?
Well, if I'm Jack Smith, the prosecutor here, I would say absolutely not, or maybe heck no, and just point to the proud tradition of our Constitution, which is at its essence, Lawrence, there's one central idea, which is no person is above the law. And what Donald Trump has done throughout his presidency, before and after, is always basically his arguments amount to, I'm above the law. So when he was president and there was the Mueller report, which outlined 10 crimes he had committed, he said, you can't indict me because I'm a sitting president. He then gets voted out of office, and then he commits crimes on January 6th to try and stay in office. And he says, you can't prosecute me because I'm still a sitting president. So then Congress goes and tries to impeach him. for this, and his lawyers go to the Senate and say, oh, no, you can't impeach him. You can only prosecute him after he leaves office. So then Jack Smith does exactly that. They prosecute him after he leaves office, and he says, oh, no, you can't prosecute me because I was impeached before and I wasn't convicted, so now I can't be prosecuted. It's all just a big shell game. It always adds up to the same thing. Donald Trump evades the law. And unfortunately today, Lawrence, the Supreme Court put its thumb on the side of saying, Donald Trump, we're going to help you evade the law. There's lots of caveats there that we can talk about in a moment. But, you know, that is, I think, the upshot of where we are today.
And do you mean evade the law simply by the delay in the trial, or are you anticipating, based on what you're seeing in this order today, that this court, 5 justices on this court, could actually find some immunity provisions to apply to this case?
I cannot imagine 5 justices, Lawrence, of the Supreme Court saying that Donald Trump has anything like a serious legal claim here. It is so antithetical to everything we as lawyers, we as citizens think about our government. And the clip you just showed before illustrates the consequences. A president can go and assassinate his political rival and say it's an official act and you can't prosecute him. That's, I mean, Looney Tunes, to put it mildly. So no, I don't think that's the worry. The worry is the Supreme Court agreed to hear this case and set a fairly slow schedule of hearing it on April 22nd. I know Trump wanted a longer schedule, but still, that's a long time. And for reasons we can talk about, when you start doing the math, there's a real risk that Donald Trump could evade justice and evade this prosecution.
It seems, according to the question that the Supreme Court is asking, that this could be a narrower argument in front of the Supreme Court. Apparently there will be nothing about double jeopardy. They seem to, because those are the 2 questions that the Trump lawyers brought to the Supreme Court, the double jeopardy and this immunity for official acts, or, as the Trump lawyers put it, acts that are at the outer perimeter of official duties. It seems that discussion about the perimeter and what is an official act will be the focus of this argument.
That's exactly right. Donald Trump's lawyers had made another argument about double jeopardy, which was even more bogus than their absolute immunity one. And that is really saying something. I mean, you got to try to come up with an argument that's weaker than the absolute immunity one. But Donald Trump's lawyers managed to find it. And the Supreme Court didn't bother wanting to hear that piece of it. You're absolutely right. So it does turn on this absolute immunity thing. And the way that the court has written it, they've written it in such a way it says alleged official acts. And by the alleged official acts, they don't mean what the prosecutor is alleging. They mean what Donald Trump, a former president, is alleging. And the idea that someone can just stand up and say, well, because I was a former president, I'm alleging these are official acts, like trying to launch a coup on January 6th. That's an official act. And now you have to evaluate my immunity claim. That can't possibly, Lawrence, be what the law is. So I'm not worried about the Supreme Court ultimately doing the right thing when they hear this case. I'm worried about how long it's going to take for the Supreme Court to do the right thing and whether the American public is going to be deprived in the interim of actually Donald Trump ever reaching justice. And there's one other point I'd make about this, which has to do with prosecutorial norms, because there is an informational asymmetry here. During this whole delay period, while the Supreme Court hears Trump's case, Trump can go out to the cameras and say the case is bogus and attack Jack Smith and all sorts of stuff. Federal prosecutors don't act that way. They only get to speak through their filings and their presentation of evidence. So now with these months and months of delay, that's great for Trump. He's going to get to claim he's being persecuted without the public ever having the opportunity to actually hear the very persuasive evidence against him or a jury to hear those things.
Professor Tribe, so glad to have you here tonight on this important night. What is your reaction to the Supreme Court deciding to hear this case?
Well, I was quite convinced, given how long they were taking, that they were likely to decide to hear it. What I didn't know, and what is very disappointing is that they would formulate the question presented at a level of enormous abstraction so that the delay that we've already seen may just be the beginning. That is, the question presented is now whether and to what extent does a president have immunity after he leaves office from criminal prosecution for conduct alleged to involve official acts during his tenure. Well, of course, Donald Trump alleges that everything was an official act. Jack Smith is at the opposite end. Instead of that, if they really had any interest in expedition, any interest in satisfying the public need to get this trial going and to have a verdict one way or the other before the election, they would have asked a narrower question. They would have simply asked whether a president charged with criminally seeking to remain in office beyond the end of his term has absolute immunity from prosecution for crimes committed in that vein. That would have been the right question to ask, and it could only have had one answer. This question is so sweeping that there are a lot of ways of answering it. Yes, the president might have some degree of immunity for some official acts, but that is not the real issue. John Roberts long ago said that if a case doesn't require you to address a particular question, then as a federal judicial official, you shouldn't answer that question. You shouldn't reach out. By reaching out in this way, the court has guaranteed not only that there would be this bizarre delay, they could have taken this issue before them back in last December, not only that there'd be that delay, but now the delay until late April before hearing the case. There's no reason to have that several-month delay. In the Bush v. Gore case, everything moved 10 times as fast. This is a much simpler matter. It could have been resolved quite quickly. And the really weird thing is that essentially everyone knows where the story has to end. It cannot be the case that when a president is in office and tries to remain in office after losing an election and commits the crimes that are involved in that he is forever immune from prosecution. Yet that is what would have to happen to give this president immunity. So since we know that that's where the story has to end, to drag it out this way and have a virtual guarantee that the court won't decide anything until late June, it might decide this broad legal question and send the case back to the D.C. Circuit. Even if it doesn't, no trial is likely to begin before October. In any event, no verdict of either kind, acquit or convict, is likely to happen before the election. And as a result, the people of the United States are confronted with basically a Supreme Court that is suppressing evidence that they need in order to decide intelligently whether the person they are voting for is guilty of the extreme felony of trying to steal an election and remain in office. That's an unconscionable way to proceed, and yet that's what the Supreme Court has arranged by the way it's organized this case.
So you're focusing on the exact words of the question, and the Supreme Court gives the lawyers the question they want them to address. Right. You're focusing on the part where it says alleged to involve prosecution for conduct alleged to involve official acts during his tenure in office. That seems, the way you're reading it, to open the Supreme Court to arguments about each particular bit of evidence in the case. Was it an official act when President Donald Trump was asking Vice President Mike Pence to change the electoral vote count? Was it an official act when he was calling the Secretary of State of Georgia? Is that where the Supreme Court could end up here, evaluating each action described in the indictment?
Or laying out a blueprint and sending the case back to the Court of Appeals to evaluate the allegations, so that this is a formula for indefinite delay. I'm focusing also on the fact that the court asks whether, and if so, to what extent is there immunity? The question of whether the immunity is absolute or reaches only to a certain extent is a complicated question, the only complicated question in this case. It's the only one that the D.C. Circuit punted on, and it may be the one that the U.S. Supreme Court focuses on, namely, what is the contour of the president's official duties? What kinds of official duties are immune from criminal prosecution? It's an sort of open season for legal scholars, legal philosophers, not the kind of thing that a court that is supposed to be deciding the case before it ought to decide. This is a way of making it a much more complicated case where the bottom line at the very end of all this backing and forthing is fairly clear, quite evident. The president can't have the absolute immunity to steal an election by obstructing the proceedings of Congress up to and including fomenting violence. That can't be immune from prosecution. Yet that is exactly what Jack Smith says he has the power to prosecute. So there's plenty of fault to go around here. Merrick Garland waited too long before appointing a special counsel. The special counsel proceeded with all deliberate speed, but even he could have gone a bit faster. This indictment could have been brought somewhat earlier. The case could have been narrowed. Perhaps it will be after the Supreme Court has its say. But if Donald Trump is reelected, the case goes away. So that even if we all agree that presidents can't be kings, they can't be above the law, after they leave, they're just citizens. Even if we all agree with that, in every practical sense, this president will have ended up being above the law because he will have managed to use the procedural gimmicks and gears of the legal system to avoid being held accountable before he could again assume office and make the whole trial go away. It's not the way a country that is concerned to preserve the rule of law and constitutional democracy would proceed. And I think the court bears some real responsibility for proceeding the way it has.
Congressman Goldman, I know you have, in effect, demanded Clarence Thomas's recusal, but he doesn't seem to follow any of the precedents on this kind of issue that we've seen from other justices.
No, and I think we have our answer. If he were to recuse, we would have seen it in today's order, and he's not. And it is absolutely baffling, Lawrence, not just because of the precedent of Chief Justice Rehnquist or then Justice Rehnquist that you point out, but the fact that his wife was involved in the conduct that underlies the criminal charges against Donald Trump, about which he is seeking immunity from the Supreme Court, and Clarence Thomas has not recused himself, is perhaps the greatest ethical lapse that we've seen in a Supreme Court justice. And under the new guise of impeachment that this House Republican majority has created with the impeachment of Secretary Mayorkas, if the Democrats win the House next year, I think we are going to have to think about what our actions are in terms of reining in this rogue Supreme Court, bringing judicial reform and ethics back to the court so that its credibility is restored, and even up into and including the possible impeachment of Clarence Thomas because he continues to flout basic common sense rules of ethics for any judge, much less a Supreme Court justice.